Maya, I am here.
Okay, great. And your video is on?
Yes. While I'm joining, it shows I am visible, but once I'm in the room, I am invisible.
Oh, I really don't know how to go about this. Girls, do you know? Technical team. Okay,
Just
Sophie,
Ma'am, is
it's
it
a request. Do you
possible?
have some kind of background that you can show? Yes, go ahead, Sanya.
Ma'am, is it possible if ma'am could, join in through her phone for the video?
okay, I will try that now.
Sophie, don't exit, just try and join with your phone. So there'll be two devices. Once you get in through your phone and your video's on, then you can exit from your desktop.
Okay, Maya.
Who else is here who's from the core team? Second year and third year?
Ma'am, I am from.
Yeah, so you're a second year or third year student of WSC?
Ma'am, I am
Core
from
team?
second.
And you're in the core team?
Yes, ma'am.
Yeah, so the request is that please, I request the second and third year, at least 10 students, second and third year from the core team, whoever is here. And at least 10 of you, we need you to exit the room. Otherwise, entry of the resource person is getting difficult. It's affecting her entry and her video.
All right, ma'am. I'll leave. I just have to take an attendance.
Okay, so who else is here from second and third year core team? Please exit and navigate to. Okay, can we see? I saw Dr. Sophie Joseph briefly. Can others also see her? Sophie, can you hear? Sophie, we saw you for a brief minute if you had logged in from your phone.
Ma'am, she's left the meeting. She is visible now.
Great. Hi. Good
Hi,
morning.
hi. Very good morning.
Much better now to be able to see you.
Yeah.
Yes.
Yes.
I don't know why that happened because people have
Yeah.
used laptops and desktops. It hasn't been a problem
Okay.
in the past.
Okay. 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 I don't know what is this.
So now, Jolene, no, but now it's okay. Your voice is clear
Okay.
and we can see you.
Okay. That's good.
So we have a little bit of an introduction first. So we'll first start with the introduction. And Jolene, we are live. What is the scenario? Oh, great. Okay, so let me also press recording.
Yeah.
Yeah, go ahead, Sophie.
I'm just reorganizing the mobile, just to make it hands-free. So.
Sure.
Okay. Go ahead. Shit.
Ma'am, can you press the record button as well? Shreya, you can take over for the introduction.
Okay, thank you. Good morning to one and all present here. I, Shreya Singh, on behalf of Women's Studies Center, Jesus and Mary College, would like to welcome you all for the fourth session of the certificate course module on India's laws from a gender and human rights perspective. The topic for today's session is marital rape, a legislative and judicial conundrum. To throw light on this topic, I would like to welcome the today's speaker, Dr. Sophy Joseph. Dr. Sophy Joseph is an assistant professor of law at the National Law University, Delhi since 2013. She was postdoctoral fellow in the project Laws of Social Reproduction, sponsored by European Research Council, anchored by the King's College of London. She focused her research on paid domestic work. Her subjects of teaching are labor and development, unorganized sector in the labor and legal history at the university. During her postdoctoral research on paid domestic work, she studied the sector from interdisciplinary perspective, understanding feminist discourse, political economy viewpoint, and non-legal recognition of women's work. In her doctoral study, she studied farmers' rights in neoliberal India, wherein she analyzed the impact of legal policy reforms during Second Green Revolution phase on farmers' customary rights and livelihood, particularly in the context of the extension of private property rights to plant varieties and seeds and migration of cultivators to the cities. She is engaged she is engaged with many policy initiatives with the international organizations, state governments, law commission, and civil society organization. Her policy works include assisting in drafting of labor policies, bill on domestic workers, rule making for bonded laborers, drafting policy for the protection of early childhood care and development, uniform legislation for informal sector, etc. Her recent policy work included drafting bill for domestic workers titled Domestic Workers Regulation of Work and Social Security Bill 2017. She is also part of assisting litigation in the Supreme Court for the construction workers and domestic workers. She had been part of various projects such as UNDP Coal Project on Access to Justice for the Marginalized, the construction workers at Noida, and IGSSF project on impact of the BOCW Act on the construction workers in India. She is currently assisting the Chhattisgarh government on rulemaking process related to the 4 labor codes. We are delighted to have you, ma'am. I would request the audience to kindly mute themselves, and in case you have any questions or comments, kindly put them in the chat box. I now request Dr. Sophy Joseph to take over and enlighten us with her knowledge. Ma'am, the floor is all yours.
Sophie, I just have one request. You're coming in a way in which you're not straight in the live streaming also and currently on Google Meet. If you keep your phone vertically straight, rather than keeping it horizontal, then you appear horizontal and you appear ulta on our screen.
Oh.
So can you keep the phone straight, vertical? Then it will be a... So rather than horizontal, if the phone can be kept vertical. Great. Fantastic.
Okay, thank you, Maya, for the opportunity again. Thanks for the warm introduction. So today we're going to interact on the law of marital rape and its implication on gender jurisprudence in India. In last 2 days, especially from different courts in India, we had been hearing legal news on rape cases. 3 such instances are amongst 3 such instances. 2 instances are from the trial courts in Kerala. So recently we came across Bishop Franco Mulakil was acquitted from rape case instituted by a nun from Missionaries of Jesus congregation. Just the judgment has come out very late in the evening. While we glance through the judgment, we see that the point that has been noted by the trial court to acquit the rape accused in this case is the inconsistency in the statement of the complainant. So the trial court basically states that she couldn't come out as a sterling witness in this particular case. So the standard of clarity that the court expect from the victim, the survivor here in this case, is something that needs close introspection and critical analysis in this case. And the second rape case is about it's very famous case which is going on in trial court again for last 4 years. The case is being filed by a South Indian actress against a Malayali actor, Mr. Dilip. And we see that the case is about the conspiracy to scheme rape on her. The case against the actor is criminal conspiracy to scheme rape on her. The case is again before the trial court, and we have seen many dramatic turns in this case, including most of the witnesses in favor of the complainant turning hostile during the process. The witnesses mostly being the witnesses from the colleagues from Seinfeld, both actors and actresses turning hostile in favor of the accused in this case. As we look through this case, the consistent grievance on the part of the survivor is also insensitive attitude of the judge, and also the attempt to derail this case through unfair means. And yesterday, when we look at the statement of the solidarity group in favor of the nun, we see that they're also alleging the unfair intervention in this case, the unfair intervention of the powerful accused men in this case. And that's the same in this case as well. In the celebrity actress case as well, we see that she has been consistently complaining about the outside intervention, extraneous intervention, and in unfair intervention in the trial process. When we look at the conduct of trial processes in rape cases, one thing that is very clear is the kind of standard of material evidence that the court demands in rape cases. So we see that there is the patriarchal mindset of the judges. The judicial patriarchy also looks for material evidence of high standard. It's basically the consumption of the patriarchal society, which converges with the dominant emotive standards of the public morality. So we see that there is a pervading patriarchal mindset with which even judges approach rape cases. The third instance that is definitely, which is very relevant for our discussion today, it's about the cases, ongoing case before the Delhi High Court. There are a batch of petitions combined together with the Delhi High Court exactly on the question of marital rape. And this is all about, the case is all about how, I'm just, So the case is, again, it's about how marital rape is unconstitutional at the face of constitutional law. The argument that is it's consistent to be argued by the amicus curiae in this case that the artificial creation of exemption for marital rape is nothing but a legal jugglery, and it definitely goes against women's dignity and their autonomy over their personality. So these three cases takes our attention with service the contemporary discussions on rape that is going in different courts today. What is important to look at is how the trial courts especially approach rape cases, and how they look for loopholes in the statements and in the statements of the witnesses and the complainant to turn the case in favor of favor of the accused. That's one important glaring reality in the judgments that we see today. Before explaining the legal technicalities of marital rape, I think it's also important to look at the nature of the offense, that is rape in general. If you look at the NCRB data, the total number of rape cases reported in India in 2020 amounted to almost over 28,000. This is despite that in 2020, people were largely homebound because of lockdown. So this itself says the amount of rape cases in India. And as we look at the crime of rape is considered to be a crime against body, and it comes under the gamut of sexual offenses under the IPC. Rape is considered to be a grave and systematic human rights violation, and it's a gender-based violence against women. It's violence not only against women's body, it intervenes with individuality, it intervenes with the right to privacy, emotional stability, and status of women as such. So the perpetrator of the crime views women's body as an object for inflicting violence for varied motives, maybe desire, revenge, emerging out of multifaceted reasons, status, etc. Rape is viewed as a form of male oppression, and it's considered to be a crime, a tool that is being used to exercise control over women. It is extremely traumatizing for the victim, as it has long-term repercussion on her mental health and well-being. When we look at developmental debates, the developmental debates argue that the violence against women has adverse effects on economic growth and development because of loss of productivity, and it also affects women participation at workplace. Indian feminist movement has consistently been involved in expansion of rape jurisprudence in India from 1970 onward. It was in 1970s we see one of the important intervention from part of legal preliminaries post Mathura judgment in 1978. So in Mathura case, a tribal girl was raped by the policeman while she was in custody. And while the High Court dealing with the case acquitted the policeman, stating that she is habituated to sex. And another important remark that came out in the High Court judgment was whether, since the policeman belonged to upper caste, the policemen were upper caste, the question was whether upper caste men would do rape would commit rape on a lower caste woman. So these misogynist statement, this casteist and misogynist statement in the judgment created a large backlash against the judicial stand, and that provoked the feminists and the jurists to write to the Supreme Court, which resulted in expansion of rape law to include custodial rape under IPC, and also to increase and also to reduce the burden of proof on the complainant. With this introduction, we will also try to understand how the law defines rape under Indian Penal Code. With the enactment of Indian Penal Code in 1860, India was brought under a uniform and systematic criminal law. So Thomas Macaulay, while introducing Indian Penal Code, his intention was to create a uniform law for all, because till then we know that there were different systems, there were different criminal justice system on the in the line of religion. The religious laws regulated the criminal justice system till 1860, in the sense, till the introduction of Indian Penal Code. So why Thomas Macaulay intended to create a new pattern of law and order in society by bringing Indian Penal Code. However, while we look at Indian Penal Code closely, we see that there is a different categorization of women within the code. So, married women and unmarried women considered to be different, and their treatment is also different under the Indian Penal Code. As we try to understand the provision relating to marital rape closely, we will understand this figuration of married women, a different figuration of married women in IPC. After the drafting and implementation of the Penal Code in 1860, the most important provision under the IPC in relation to protection of women was Section 375. Prior to the amendment, we all know that there was an amendment in 2013 to the IPC, post Nirbhaya. That was to expand the rape law to include the new forms of rapes in the current time. So before the amendment in 2013, if a man committed rape, a man was said to be committed rape if he had sexual intercourse with a woman under one of 6 circumstances enumerated in the section. So sexual intercourse was defined as penetration of the vulva by the penis to any extent, however slight. Ejaculation was not required. So the amendment, the law before amendment only talked about sexual intercourse, in the sense a man is said to have committed rape if he had sexual intercourse with a woman. That's how the law read before amendment in 2013. However, after amendment in 2013, we see that the rape law was expanded to include beyond penile vaginal penetration, to include penetration by the penis or penis of orifices other than the vagina of a woman, as well as penetration by objects or body parts other than the penis into the vagina or other orifices of a woman. So that's a expansion of rape law that's been done post 2013 amendment. As we look at Section 375 of IPC, we see that there are a lot of focus on the component of consent within the law. So although the acts constituting intercourse were broadened by amendment in 2013, the core issue in proving rape remains establishing non-consensual penetration. So in order to convict a man of rape, the prosecution has to prove that penetration had occurred without the woman's consent. So proving lack of consent is often crucial element in rape cases. Since in all rape cases, there are no witnesses to the act of rape, the prosecutors have to rely on the testimony of victim along with any other relevant evidence. And those relevant evidence generally are medical evidence to show that woman had not consented to penetration. So medical evidence becomes so important along with the testimony of the victim. And in Nunn's case, the Nunn's case that I just mentioned, uh, it's exactly the court talk about. The testimony of the witness was the testimony of the complainant was not foolproof. There were inconsistencies, or the story was not coming out consistently throughout the statement. So this actually makes us understand that the uh, the prosecution has to really prepare the complainant, despite the traumatizing phase that she's undergoing, to make her case, to make her statement very clear to the judge. The judge uh, doesn't look at beyond her words, doesn't consider her status as a victim survivor uh, in from a traumatizing crime. Uh, it's also important to look at certain significant judgments of the Supreme Court in cases relating to rape. The Supreme Court in 1952 basically stated that even if there are no direct evidence to link the accused with the crime, the testimony of the victim can be the sole evidence to prove the crime against the accused. So in rape cases from 1952, the Supreme Court has stated that even if there is no direct evidence to link the accused with the rape cases, the, the statement of the witness is enough to be trusted upon. However, we see that though there is clear statement of the complainant and other witnesses corroborate with the statement of the complainant, the court always looks out for other direct evidences to link the accused with the crime. Even in this Nunn's case that we are talking about, we see that none of the witnesses in the case turned hostile in favor of the accused. So all the witnesses from the complainant's side corroborated the statement of the complainant. However, the whole focus of the court was to find out a loophole in the statement of the complainant to help out complainant to find out a loophole for proving the case beyond reasonable doubt. So we see that there's an instance that the court mentions in the judgment that while giving an interview, a media interview, importance of the Nun, give a statement that there was a prior incident. There was a prior incident. It was a conflict between the accused and the complainant before filing the case. So this was taken as a prior instance of rivalry by the court to turn the case against the complainant. So generally the past history and the character of the victim, etc., being minutely looked into by the court in order to find out loopholes to state that the cases are not proved beyond reasonable doubt. So there is heavy reliance on the evidence, the medical evidence in proving rape cases. There was a section under the Evidence Act which was repealed in 2003. The section was 155 subclause 4, which actually allowed the defense counsel to cross-examine the complainant to prove anything relating to her immorality. Though this section, so Evidence Act explicitly allowed the defense counsel in rape cases to cross-examine the complainant to prove her immoral character. Though this law was repealed in 2003, the trend of looking into the past history of women or proving immoral behavior of the woman still continues in rape cases. Time again and again, we come across misogynist statement in judgments about women's the victim survivors' habituation to sex or her her past history as a deviant. The all attempt to characterize the complainant as a deviant woman. So, despite the change in law, we always see that the past sexual history, the medical examination also focuses on proving women's past sexual history to demonstrate women's habituation to sexual intercourse. So the rape law basically defines rape as now there's the expansion of rape law being done by 2013 amendment. So intercourse with references of a woman amount to rape by today's interpretation. With this understanding of rape law, I think it's important to look at how marital rape is being dealt with under Section 375 IPC. It's exception 2 of Section 375 IPC that carves out this marital impunity for the husband in the case of rape within marriage. So sexual intercourse or sexual act by man with his own wife, the wife, if the wife is not under 15 years of age, is not rape. So this exception, exception 2 provides an exemption for husband, from getting charged under the crime of rape. I think I don't need to explain what is marital rape. Marital rape refers to a rape committed when the perpetrator is victim spouse. When we look at this section 2 of section 375 of the IPC, it actually does not state any reason for exclusion of sexual intercourse or sexual act between husband and wife from the purview of rape. The crux of the focus of this section is on, in fact, the whole focus of section 375 is on consent. It is, but when it comes to this exception, where the law presumes that, law states that if there is a rape within marriage, it doesn't amount to the crime of rape. There's a presumption that is very much readable. The presumption is that the consent, there is a presumption of consent operates when the relationship between the victim and the perpetrator is that of marriage. However, at the same time, it is also possible that this was a legislative decision to exclude the operation of this section from married relationship, given the sanctity that this institution has assumed in our society. Under the law of rape, there are two presumptions that we generally see. The first presumption is that, okay, the consent does not exist in the case of if it's a minor. In the case of minors, it's presumed that consent does not exist. In the second instance, the law presumes that when the victim and perpetrator are married, the consent is presumed to exist. So in the case of minor, the law presumes that minors cannot give consent to sexual act. In the second case, in the second instance, the law presumes that if the perpetrator and the victim are in the relationship of a marriage, then there is a consent for sexual activity at any time. So this presumption of consent is something which is very underlying to the exception clause under Section 375. If we look at globally, there are actually more than 52 countries which has recognized marital rape as a crime. There are a lot of justifications that has come out in order to not to address or not to criminalize marital rape as a crime. The first justification stemmed from the understanding of the wife as subservient to her husband. So women were chattered to the husband, and this meant that women did not have any rights in the marriage. In such a scenario, it would not be possible to fathom a husband raping his wife, since the husband was the master to the wife and enjoyed privileges over her body. Along with this justification, there is unitized theory also existed. This theory rested on the idea that after marriage, the identity of woman merged with that of her husband. Therefore, law did not give married woman a personality independent of her husband. This is linked to the previous justification in terms of looking at women as chattel of the husband. There are more nuanced theories which have become the justification for marital rape. One is the implied consent theory. Here, there is an irrefutable presumption of consent is thought to exist when a man and woman enter the institution of marriage. So marriage is considered to be a civil contract, and consent to sexual activity is thought to be the defining element of this contract. So that is implied consent theory. The fourth justification, which is the most recent, is that the criminal law must not interfere in the marital relationship between the husband and wife. It comes from the argument of private sphere, which the law must not penetrate into. While the law does not criminalize marital rape, there is a specific form of marital rape that the law talk about. That means under the exception, the marital rape is exempted. However, there's a provision where rape within marriage is criminalized. It's basically non-consensual sexual intercourse when the wife and husband are living separately on account of judicial separation or otherwise. So if the husband and wife are living separately before their legal divorce, then non-consensual sexual intercourse would become rape. So that's the only provision where we see the rape by husband as being considered rape under the law, under the criminal law. As we look at the legislative recommendations on marital rape, there have been at regular intervals there have been arguments to look at marital rape differently, especially in the context of transformative constitutionalism and also from gender justice angle. The first time it was Law Commission in 1970. It was 42nd Law Commission report of 1970, which closely looked at the provision relating to marital rape. However, after the deliberation, when the report came out, they kept aloof silence on the exception on marital rape. But there was a recommendation for considering rape by husband rape by husband or wife during judicial separation or otherwise to be considered as a crime of rape. So 376B, which talks about marital rape during separation, during the phase of judicial separation or otherwise, was included after 42nd Law Commission report. But during the 42nd Law Commission report, though there was deliberation on criminalizing marital rape in general, that was not accepted as a that was not included in the recommendation. Lately, it was after 3 decades later, it was in 2000, in the 172 Law Commission report, there were deliberations on marital rape. However, we see that the reasoning that was given for 172 Law Commission report, in fact, give a reasoning for non-intervention with the marital rape provision under the law. So it basically stated that any intervention with exception of marital rape under the criminal law rape would amount to excessive interference with the institution of marriage. So there was a lot of discussion on interplay between marital rape and sanctity of institution of marriage, and the report gave weightage on sanctity of marriage for not to criminalize marital rape. After 2000, we see a powerful intervention in Justice J.S. Verma Commission report. So his report advocated for criminalization of marital rape. And this report also discussed how immunity is granted to the perpetrator if his husband of the victim stemmed from the outdated notion of women being the property of men and irrevocably consenting to the sexual needs of the husband at any time. It remarked on this impunity, judicial impunity allotted to a husband under the presence of legal framework. J.S. Verma Commission also talked about evolving nature of gender rights framework and how this has influenced outlook towards marriage as a contractual relationship. However, we see that the recommendations were not taken into the policy document. When the 2013 law came in, despite these strong recommendations on criminalizing marital rape, the provision, the exception from rape under the couch of marital rape exception was kept intact. In 2015, there was again this discussion on marital rape at the cabinet level, and followed by this cabinet discussion, the Ministry of Home Affairs they replied to a bill presented by a private bill presented by a member of parliament, which intended to criminalize marital rape. The statement of the Ministry of Home Affairs also stated that it was considered that the concept of marital rape cannot be suitably applied in Indian context. So basically stating that Indian culture wouldn't allow such a liberal concept to be imported as it intervenes with the stability of family system in India. So we understand that one of the strong reasons against the criminalization attempts to against criminalization attempts of marital rape as mindset of the mindset of judiciary and the mindset of the uh, uh, legislature to treat marriage as a sacrament, and this attitude also emerges from the wider habitus, the wider society. As we look at the debates on marital rape more closely, we see mainly five arguments against the criminalization of marital rape. The first is with regard to the goal of protecting the institution of marriage, as we just talked about. So it's under the couch of protection of institution of marriage, this non-intervention into private space being constructed upon. And this has also strong connection with arguments related to cultural relativism. So proponents of this argument basically state that criminalizing marital rape is intruding into the private space, into the privacy of the sacrament of marriage. And this is definitely visible, the exception clause, and also under the 42nd and 172 Law Commission reports. So the first argument is relating to protecting culture, protecting the institution of marriage, and non-intervention into the private space. The second argument against criminalization is about the alternate remedies available under the existing law. So basically stating that there are different laws enacted under different legal regime to protect women from violence, both physical and emotional violence. So marital rape need not be explicitly termed as a crime under the law. And they take this argument by stating that, by especially pointing it out at Section 498A of the IPC that talks about cruelty against women within matrimonial homes, and also looking at the provision under the Protection of Women from Domestic Violence Act 2005 and Section 13 under the Hindu Marriage Act. Section 498A of the IPC, which talks about cruelty within inside matrimonial house, it protects women from violence. It's termed as violence. And by judicial interpretation, the terminology cruelty is expanded to include mental violence as well as physical violence. So the argument actually basically stating that 498A since it's expanded through judicial interpretation, even forceful sexual intercourse by the husband can also be brought under Section 498A. So for that, there is no need for creating a separate crime under the rape provision. Under the Protection of Women from Domestic Violence Act 2005, we know that DV Act mainly provides civil remedies, injunctions, and compensation. So since there is available civil remedy regime that also takes care of women's economic demand. So that is another set of laws that protect women. So they don't need a separate regime. When it comes to Hindu Marriage Act, they basically say that there's a ground of divorce, which is cruelty under the HMA, Hindu Marriage Act. And cruelty would include even marital rape. So on the ground of marital rape, a woman can approach for divorce under the Hindu Marriage Act. So since there are different laws to protect women against cruelty, there is no need for a separate provision to protect married women from forceful sexual intercourse. That's one argument. The third argument against criminalization is, which is a very old justification for marital rape, it's the implied consent within a marriage. And this was stated even when this implied consent theory, it was articulated even when IPC was framed in 1834. So if you look at legislative debates relating to IPC, this canonic interpretation of marriage is very much visible in the legislative debate. Especially the wordings of Sir Matthew Hale of England. So that has been quoted in the legislative debate. Sir Matthew Hale of England, he declared that the husband cannot be guilty of rape committed by himself upon his lawful wife, for by their mutual matrimonial consent and contract the wife hath given herself up in this kind unto her husband, which she cannot retract. So there is an implied consent the moment you enter into a contract of marriage. So she cannot retract from her obligations of matrimonial relationship. And sexual activity is considered to be a matrimonial obligation which she cannot retract from. And it's with this attitude that the exception is being made under Section 375. And this historical justification is again reflected in Blackstonian jurisprudence. So Blackstone also contended that by marriage there is this Blackstone theory basically talks about a unitized theory. And he states that by marriage, the husband and wife become one person in law. So they have no separate existence after marriage. Hence, it cannot be stated that husband commits a crime on the wife. So they are one person in law after marriage. So the legal existence of a woman is suspended after the marriage. That's what Blackstonian theory talk about. The fourth argumentation against criminalization is about the statistics, using the statistics, basically stating that there are very few cases that comes to the public domain as marital rape case. This is a very flimsy argument considering the general social construct and the patriarchal mindset and society. There are very specific reasons for married women not coming out with marital rape cases in Indian context. Lastly, fifthly, the defenders of the marital rape exception, they state that there would be misuse of law. There would be misuse of this provision if once it is introduced as a crime. This argument is this misuse of law argument by women. We have seen this argument time again and again under different protective provisions. So if we look at DB Act or 498A or Dowry Prohibition Act, it's a general statement that women misuse the provisions, protective provisions under this law. Even the Supreme Court in 498A cases, in both Arnish Kumar case versus State of Bihar and Rakesh Sharma's case in 2018, has talked about the misuse. In fact, they recognized or acknowledged the misuse argument against these provisions, against protective provisions. I think as we look at these 5 main arguments against criminalization, it's also important to cross-verify the validity of this argument. So we see cultural relativism argument as first argument. Second argument is available legal remedy under other legal regimes to protect women from marital rape. The third argument is about implied consent, how marriage is a sacrament, and there is implied consent as they enter into a contract of marriage. Fourth is about how less cases are reported, so it's not a crime that requires legislative attention. Fifth is about the argument of misuse of law. And since we are making critically looking at the marital rape provision under Section 375, it's important to cross-verify these 5 arguments. Mainly the cultural relativism argument. As we look at the argument of marriage is a sacrament or marriage is a sanctified institution, we know that the state does not compel any two individuals to marry or divorce. So, however, the refusal of the state to enter this private space, even in certain specific instances, can be problematic. For example, if a wife is subject to cruelty in a marriage, then the state will have to enter this private sphere to criminalize this cruelty that the wife is subject to. If the state does not do so, then the woman will have no redressal legally. So it is important for the state to penetrate this private sphere on certain occasions. Marital rape is also a violation of fundamental right of a woman, specifically under Articles 14 and 21 of the Constitution. We argue that lack of criminalization of marital rape infringes on the fundamental right of a woman. Even though this crime of marital rape occurs within the private sphere of marriage, it is the responsibility of the state to penetrate through this private sphere. If the state does not penetrate this private sphere, then a woman is left without remedy when raped by her husband. However, an analysis of judicial decisions with respect to matters traditionally conceived to be within the private sphere of marriage and family highlights the hesitation of the judiciary to bring in fundamental rights in the private sphere. The judiciary has created this fictitious private sphere where it refuses to implement and read the fundamental rights into private sphere. The effect of this has been to negate the question of whether marital rape is an infringement of fundamental rights. This is because in the perceived marital sphere, there is no role for fundamental rights. And it's interesting to look at how judiciary has made conflicting decisions in this regard. I think one of the corollary analysis that we can make is along with the provisions relating to restitution of conjugal rights under the Hindu Marriage Act. While we look at the judiciary's approach toward restitution of conjugal rights, the non-interventionist approach of the judiciary is very clearly visible. So I think the constitutional issue relating to intervention of or fundamental rights into private sphere or use of fundamental rights jurisprudence to get into private sphere can be demonstrated by using the jurisprudence relating to restitution of conjugal rights. A restitution of conjugal rights is a remedy that originated in English law, although it no longer exists in England. It is a mechanism through which a court may pass an order compelling a married couple to live together. In India, under the Hindu Marriage Act, Section 9 talks about restitution of conjugal rights. So the gist of this section is that if a husband or wife does not live together without a reasonable excuse, by a decree under this provision, the court can compel both of them to cohabit under the same roof. In most of the times, women are, in all the cases, women are often forced to resume conjugal relations with their husband. Here, similar to the debate on marital rights, the central question is whether the state can compel a woman to have sexual relationship with a husband. This question was confronted by the courts at different times. One of the important instances was in a case titled T. Sarita versus T. Venkata. It was a 1983 judgment by the Andhra High Court. So when the question of law relating to the state power to compel a woman to have sexual relationships with their husband under Section 9 of Hindu Marriage Act, under the restitution of conjugal rights provision, the court gave a very liberal, very progressive jurisprudence in this case to state that the restitution of conjugal rights provision violate Article 14, 19, and 21 of the Constitution. So basically, the court even talked about the right of autonomy of an individual. The court also accepted that women would be hurt by the provision of restitution of conjugal rights, and it actually intervenes with sexual autonomy of a woman. So no act of sex can be forced upon the unwilling person, because nothing can conceivably more degrading to human dignity and monstrous to human spirit than to subject a person by the long arm of the law to positively sex act. So this was considered to be 1983 Sarita judgment was considered to be a progressive judgment, wherein the court agrees with sexual autonomy of women, and also stating that, in fact, it held that the court held that the restitution of conjugal rights provision intervenes with Article 14 right to equality of women under the Constitution. However, post 1983 judgment, there was a 1984 judgment from Delhi High Court, Harvinder Kaur versus Harmandir Kaur. So, in Harvinder Kaur's judgment, the Delhi High Court took a very opposite stand. So, departing from Sarita's jurisprudence, the court upheld the constitutionality of restitution of conjugal rights provision, stating that here the intention of the section is not to force anyone to cohabit with the spouse, but to protect the institution of marriage. So basically, the court disagreed with the view that this provision forces the women to enter into sexual relationship with the husband. One of the interesting arguments that the court takes in this case is the court talks about marital privacy. The court says that the law shouldn't enter into marital privacy. In the wording of the court, in the wording of the Delhi High Court, it basically states that the introduction of constitutional law into ordinary domestic relationship of husband and wife will strike at the very root of that relationship and will be a fruitful source of dissension and quarreling. And it went on by stating that there is a marital privacy that the husband and wife is entitled to, and the constitutional law the fundamental rights shouldn't enter into the walls of private sphere. So the court refused to, with this jurisprudence, the court refused to enter into the question of autonomy, the sexual and personal autonomy of women. Largely, the debate revolved around the privacy question in these cases. While looking at Sarita case and Harvinder Kaur's case, we see that the concept of marital privacy being looked at from two angles. In Sarita's case, the court talks about marital privacy, and in marital privacy, the individual also has autonomy over their body. It talks about sexual and individual autonomy. And using this argument of individual autonomy, the right to privacy, the court struck down the constitutionality of restitution of conjugal rights. Whereas here, in Harvinder Kaur's case, we see that the court uses the same argument, marital privacy, to state that this is marital privacy that husband and wife enjoys in the institution of marriage. So the court shouldn't intervene with marital privacy. So that's why there is an argument that we should move away from privacy argument to autonomy argument while we advocate for gender rights. It's also right to choice, which should be looked at more from the perspective of gender rights rather than getting into the anatomy of privacy within institutions, especially legal institutions like marriage. As we look at the conceptualization of private sphere by the judiciary, it's flawed even from the perspective of constitutional law. The constitutional law talks about equality, right to life, and equal opportunity for everyone to engage in public life. So this creation of private sphere to immune marital rape from the crime of rape goes against the very right of woman to stand as an individual and to take decisions of her own and to live with dignity. And as I stated, since the IPC itself considered married women differently, this classification of married women and law differently for married women also doesn't stand the test of reasonable classification. We're carving out a assumption under the criminal law, not to give the same right to married women to get protection from sexual crime. So this provision doesn't also stand the test of reasonable classification under Article 40. More importantly, today, the understanding of the concept of marriage has also evolved over a period of time, as it is considered as a is considered as contractual relationship, even under personal law regime. It is not possible to infer anymore that the husband is dominant in the relation. Husband can take dominant hand in sexual relationship within marriage. So law doesn't look at a contractual relationship with the hegemonic eye, especially in under the contract law. The parties should willfully engage in a contract. There shouldn't be any forceful consent to the terms of contract. So this goes against the basic tenets of the contract law itself. Another, the second argument that we have gone through is about how other legal remedies provide protection for women from marital rape. While we counter this argument, we see that Section 498A, 498A was introduced into IPC with a very different, through a very different deliberative process. So it was violence against women movement, which took up the argument that there should be a specific provision to protect women within matrimonial house from cruelty. And feminist literature has long understood the importance of recognition of rape as a separate crime. The crime of rape is very much distinct from cruelty, provision of cruelty. It's true that it subsumes, the rape also contains the element of cruelty, but it's definitely distinct, definitely different in gravity and in relation to the nature of the crime, especially the stigma attached with rape itself makes the crime very different from the cruelty provision under Section 498A. And the other arguments that Domestic Violence Act is available, the provision of the Hindu Marriage Act is available. These are civil laws. So civil laws have its own limitation to provide remedies when it comes to crime. So crime of marital rape cannot be neutralized by using or trivialized by using civil law remedy. And the whole argument that there is a role of culture in determining whether marital rape must be criminalized or not. When we look at the relationship between the culture and law, they share a symbiotic relationship with each influencing and being influenced by the other. But when we look at the demand of criminalization of marital rape, it is based on the Constitution, not on the culture. And while we look at the concept of morality under the Constitution, though under Article 19.2, it talks about public morality. Now, under Article 19.2, though there is a word called terminology public morality in the Constitution, the court has read it very clearly that public morality under the Constitution should be read along with constitutional morality. What is constitutional morality that the law talk about? So the morality of the Constitution espouses the concepts of equality between sex and the right to bodily autonomy and the right to bodily integrity, privacy, and privacy under Article 21. So these forms, these important, these cardinal rights forms important part of constitutional morality. So the public morality cannot exist in contrast to the constitutional morality. Here, while we look at the cultural argument that the opponents make in relation to against advocacy movement for marital rape, this cultural argument evolves from public morality and goes against tenets of constitutional morality. So it cannot stand, it cannot pass the test of constitutionality from the legal angle. The argument that a crime is culturally acceptable is not a reason to not to criminalize it. And if anything, it should act as a catalyst to criminalization since it indicates the culture which is accepting towards a crime. So the culture that accepts a crime should be criminalized. So that should be arrested by using the law. So the cultural argument, cultural argument that the criminalization of marital rape would intervene with culture won't stand in the context of the constitutionality. While we look at the model for criminalization of marital rape, I think one important document to look into is J.S. Verma Committee report. So in the J.S. Verma Committee report, part 2 of the J.S. Verma Committee report, give a 4-pronged suggestion to effectively criminalize marital rape. So first, ask for the removal of the exemption clause. Secondly, it asks to specifically mention that it's not a defense. Thirdly, it talked about removal of presumption of consent in marriage. Lastly, it talked about application of same sanction system, punishment system for marital rape. So the 4-pronged suggestion under the J.S. Verma Committee stand as a model towards criminalization of marital rape in the legal debate relating to marital rape. Another important provision to be looked into is Section 376(2) of IPC, which talks about rape by non-person. The rape by non-person. So the person's in authority or in a fiduciary relationship commits a rape, then they are liable for punishment for a period of 10 years. So one alternative to look into is, since husband being a person in intimate relationship or immediate relationship, whether 376(2) can be used to punish husbands in marital rape. So that is another route which we can explore to make husbands liable for marital rape under the existing law. So as it comes to the conclusion of our interaction today, we understand that criminalization of marital rape is important in order to provide substantial equality for married women. And it is also crucial to recognize this major lacuna in criminal law which defeat the constitutional provisions, constitutional protections that grant women equality and autonomy. As we have continuously dealt with, there have been stiff political, legal, and cultural arguments against criminalization. But we also see the shallowness of these argumentations in the context of the legal paradigm and the gender rights paradigm, or from the Constitution itself. So this exception clause under Section 375 is unconstitutional as we look at against the constitutional morality, especially the principles relating to constitutional morality and the Constitution. And we see that there's an ongoing litigation going on before the Delhi High Court on this issue. And the amicus curiae of the Delhi High Court in this matter vociferously arguing that this unjustified and injusticiable classification of married women versus other women under the same law cannot stand the test of equality. So we are looking forward to the outcome of this case, and also believe that the crux of J.S. Verma Committee report, especially four-pronged suggestion of J.S. Verma Committee, would be taken into consideration, and in near future, like we have seen in the case of adultery, adultery was struck down by the court in a recent case. So we also expect that in the near future, marital rape exception, which goes against women's right to autonomy and integrity, would also be struck down. With this, I end my dialogue and looking forward to interacting with you.
Thank you, ma'am, for such an insightful and an interactive session as well. Now we open the floor for the questions. Members, if you have any questions, kindly put them in the chat box or feel free to unmute yourself.
Sorry, I cannot see the question.
Ma'am, we'll wait for 3 to 4 minutes. If there are any questions in the chat box, I'll read it out.
Okay, thank you.
Ma'am, I'm assuming the session was, quite insightful, and it's taking some time for members to sink in. I think Sandhya has a question. Sandhya, go ahead.
Good afternoon, ma'am. It was a very enlightening session. Thank you so much, ma'am, for that. Ma'am, so I had a question relating to the point where you mentioned the act of prevention of domestic violence. So, ma'am, last year we had a session with a lawyer who was related to an organization in Delhi called Majlis. And we had discussed this perspective of, why marital rape is not legalized. So she pointed an argument saying that, within the Prevention of Domestic Violence Act, we have the mention of physical violence, that the husband can be convicted for committing rape under this particular segment of physical violence. So, why do we need a separate legislation for marital rape? So, ma'am, do you think that this particular argument is viable for convicting the husband for marital rape, or does it has some kind of drawbacks?
Okay. Should I wait for more questions or shall we?
Ma'am, you
Okay.
can answer. You can go
Okay.
question by question.
Okay. So, Sandhya, very interesting question, very important question. While we look at protection of women against domestic violence act, this act provides only civil remedy. So it's basically civil law. There are two legal remedies that generally exist under our legal regime. One is criminal remedy, the other is civil remedy. Criminal remedy is punitive system in the sense there is punishment, there is imprisonment, it's punishment oriented system. Civil remedies concentrate on penalties, damages, compensation. So, under the Protection of Women Against Domestic Violence Act, the remedies are civil remedies. So, it's only injunctions, certain compensation, damages, compensation, and certain economic rights available for women. So the question is whether marital rape can be addressed by using the civil remedies under PWDA. Since PWDA has limitation as to give criminal punishment, it only provides damages, civil remedies. There requires a protection regime which is oriented toward criminalization of marital rape. Hence, there is a punishment being meted out to the perpetrator. So PWDA is not enough as there is no penalization involved, punishment involved. PWDA definitely gives accessibility to damages, the compensation system. So that gives that supports the woman during the phase of tormentation, but it doesn't punish the perpetrator for his crime, for his wrong. So that's why we argue that this exemption from punishment, and as we look at IPC under Section 375, the rape is considered to be a crime. It's crime against the society, crime against the body. It's a sexual offense. So rape is a sexual offense under the IPC. And why is it that there is a exemption for husband? There's the impunity, judicial impunity for husband explicitly under the law, while the law has to operate uniformly on everyone. So there is an artificial classification that's been done within the rape law between women and married women to protect husbands from getting charged under under Section 375. So this artificial classification goes against the right of women, married women, whereas because crime is a crime, rape is a crime, and this exemption actually allows them to get impunity from being punished. PWDA is it's a very PWDA is a very important legislation considering the because it provides economic support to women in the form of entitlement to matrimonial property, entitlement to matrimonial house, stay in matrimonial house, and also the damages for the violence they have undergone, etc.
Thank you, ma'am. Ma'am, I also had one more question regarding the case that you mentioned initially about Bishop Franco. He was posted as the bishop for our jurisdiction, Jalandhar Diocese, when the whole case opened up. And we had a lot of patriarchal arguments within the community of parishes and priests that how can a holy person, the bishop, like who's responsible for running the entire church in the jurisdiction, commit such a crime. So there was also this argument that why the nun is filing an FIR after like a lot of years. Why did she take that gap to legally fight a case? So, ma'am, can we say that all of these patriarchal mindsets are also because we don't really have, much women judges in the court?
I think it's all about the mindset of the judges. In Bishop Franco's case, while we look at the judgment, after I glanced through the judgment last evening, the whole attempt is on there was to find out an ulterior motive for filing this case from the side of the complaint. So all inquiry is into finding out an ulterior motive behind this case. So the case is not focusing on the actual commission of rape, instead looking at the past character, past events, or sexual character, or immoral character of the complainant in this case. And I think this is constant scene or constant argumentation that we see in the judgment from the beginning. Even in Madura judgment, the court was talking about Madura's habituation to sex. How that become important in rape case? How the statement habituation to sex or her past sexual life, how all of this becomes matter in a rape case. Even in Benwari Devi's case, the reason for the rape case, which became reason for Vishada judgment. Even in that case, the court, the High Court judgment asked a question: how come whether because the perpetrator of rape over Benwari Devi were two brothers. So the judgment even asked a question whether it's possible that brothers commit rape on a woman. So the court is always alarmed at the court is generally finding out loopholes from the complainant statement or the circumstances to save the defendant from the rape cases. That's the general tendency that we come across recently. And there was another case. There was a case of Dalit children's rape. It was again the court was talking about lack of evidence even in that case. So from circumstances, it's proved that because the children are very minor children, so they cannot commit suicide by looking at the circumstances in which they have hanged. So there is a lot of corroborative evidence to prove the crime of rape and murder, but then there are other the court there are no direct linking evidence. So the material evidence that the court demands in rape cases are of high standard, and this past behavior and the inquiry into immoral character of the complainant is always an important aspect of the case, aspect of rape inquiry, despite the fact that the Provision of the Evidence Act, wherein the defendant counsel had the right to cross-examine the complainant to prove her moral character, has been deleted. So the pattern of inquiry in rape cases hasn't changed much.
Oh, thank you, ma'am.
While you were asking about the woman judge component, I think in the South, in the actress case, the judges, she requested for a woman judge to be part of her special court as judge of the presiding officer of special court. But we see that her complaint after 4 years of trial as the woman judge of the special court has insensitive towards her. So I think it's not the gender of the judge that matters. From the experience, we see that it's not the gender of the judge that matters, the mindset of the judges that matters.
Yes, ma'am. Thank you, ma'am.
Yes, thank you.
Ma'am, there are two questions in the chat box. I'll read it out. Why is the incapability of the husband or wife to consummate the marriage recognized as a ground for annulment of the marriage?
Incapability of what is the question? I couldn't get it.
Why is the incapability of the husband or wife to consummate the marriage recognized as a ground for annulment of the marriage?
Okay. That also comes from the understanding of the institution of marriage, because in Indian context, the institution of marriage is around consummation of marriage. There are cases where the court has also mentioned about the beauty of the institution of marriage. For example, the court in Sarita's case itself, the court talked about the character of the institution of marriage beyond sexual relationship. But in majority of the cases, consummation is an important component. The court considers consummation as an important part of marriage, and in majority of the cases, the non-consummation or refusal to do sex with the husband is considered to be cruelty, and it's under the ground of cruelty that divorce is being granted. I think it's also about the construct of marriage, social construct of marriage as an institution. Marriage as an institution is also a legitimate means for engaging sexual intercourse. That's how the society views marriage as. So that has been taken, and that popular understanding is being borrowed into judicial expositions as well. So we see that consummation becomes an important component of marriage, and under the law of divorce as well becomes an important ground under the cruelty provision.
Thank you, ma'am. Ma'am, we just have one more question by Vidhi. We often see cases where sexual intercourse is consensual when marriage is promised, but then the promise is annulled and women try to prosecute the man for rape. Where do these cases stand and how does the court look at them?
Okay. So are you talking about false cases?
Yes, ma'am. Yes, ma'am.
Okay. So see, once the rape case is filed before the court, there is a rigorous criminal justice process that undergoes. So there is an inquiry into the case, primary investigation, prima facie case, the trial process, the cross-examination process, the investigation by the inquiry by the court itself into the case. So in cases like rape being the higher category of offense, the criminal justice process itself is very rigorous. In false cases, if there is a proving that, or if there is any lack of evidence to prove the case, once the accused is acquitted from rape cases, there's a possibility that he can file a defamation case or false complaint case. In the sense, we see that under the Sexual Harassment Act of 2013, there is a provision on false complaint. So if there is a sexual harassment case filed against a man, and if it's not proved, then there is a provision that facilitates the man to file a counter case under the false complaint provision against the woman. And the man is entitled to damages, compensation, if it's a false complaint. So there are remedies available under the IPC itself in case there is a false complaint being filed and the person is proved to be acquitted from the charges. But that also involves, for example, if you have to file a defamation case under the IPC, and that also invites a criminal justice process, because you have to again prove that there was a criminal intent to defend the person in front of public using the allegation of rape or using the provision of rape as the law. So that is another criminal justice. That is another criminal process that the person had to undergo. Under the Sexual Harassment Act, there is a clear provision. If it's a false complaint, the person can file the case under the provision and get the damage. So this misuse of law, basically, the argument of misuse of law comes from it comes from a very different context. While the judiciary was talking about misuse of law, the statistic that the court relied upon was the acquittal statistic. The acquittal statistics in the case of rape cases or sexual harassment cases, the acquittal happens because of multiple reasons, very reasons. One is that the complainant may not be in a fit position to pursue the case, or there may be social and moral pressures on her to compromise the case, as the case litigation itself is a costly and longer process. So there are different measures, there are different pressures on the complainant to retract from the case. So that is not being looked into or taken into consideration, while acquittal statistics being looked into, taken by the court. So acquittal statistics cannot be a conclusive finding for stating that there is misuse of law.
All right, ma'am. Thank you so much. I would now request Shreya to take over for the. Sorry, Shreya. We just have one more question. I'm so sorry, ma'am. We just have one more question in the chat box. Shrishti asks, ma'am, from what I have often seen, the legal status of live-in relationships in India is quite arbitrary, since women in live-in relationships are entitled to maintenance from their partner, provided they have had been cohabitating for a certain period of time. Does this legal protection extend to situations like these as well, where sexual intercourse is not consensual?
Yeah. So not consensual.
Yes.
Except not. Yeah. So live-in relationship is considered differently under the law. For example, a live-in relationship is legally acknowledged for the only for the provision of maintenance and for the protection from domestic violence under the Domestic Violence Act. So basically, for the maintenance is again a civil remedy. Protection of domestic violence under the DV Act also gives civil remedy. So for in these two counts, on these two counts, women in live-in relationship get protection. However, when it comes to property rights, the women in live-in relationship doesn't have a legal right over the property. But children in live-in relationship get right to property. So for women in marriage and women in live-in relationship are treated differently by law, both in terms of their political rights and economic rights. There is no, as I said, there is arbitrariness when it comes to treatment of women in live-in relationship. This is also a law and morality question for the legislature, because again, the legislature thinks that if they expand the terminology of woman to include women in live-in relationship for the purpose of matrimonial rights, then that would intervene with the institution of family, marriage, etc. So that's the age-old argument that we hear time and again. And if there is a non-consensual sexual relationship between the woman and man in live-in relationship, the rapist provision available, Section 375 is available. And if there is a promise to marry, if the perpetrator gives promise to marry and sexually exploit the woman, then the jurisprudence is that breach of promise to marry also amounts to rape. If there is sexual intercourse under the tension that he would marry with the woman, the perpetrator would marry the victim, then the breach of promise to marry, provision under the breach of promise to marry can also taken help of. So the consistent jurisprudence is breach of promise to marry would amount to rape. So again, 375 can be applicable.
All right, ma'am. Thank you so much. Shreya, you can take over for the final closing of the session.
Now I'll start with a vote of thanks. As we come to the end of the session, I would like to express my heartfelt gratitude to Dr. Sophy Joseph for taking out time to enlighten us with her knowledge. I would also like to thank our convener, Dr. Maya Joan, and the WSC staff advisors for their constant support and guidance. I would also like to thank all the attendees who joined us today. Thank you.
Thank you very much. Thank you, Shreya, for the vote of thanks. Thank you, Maya, for the opportunity again. And I would look forward to the opportunity to interact with you again.
Thank you so much, ma'am. Thank you, members, for joining in. We'll soon be regrouping for other events and other sessions. Thank you so much. You all can start leaving the meeting.